And when he say remain, that's because they think they won.
So what I have in front of me are the following. Motion to suppress the search of defendant's cell phone on the grounds that evidence was illegally obtained. The cell phone was outside the scope of consent. Also, I have before me a motion to dismiss for lack of proper venue, that the charge is based on events alleged to have occurred on May 16th, and that the alleged crime, if it happened, did not happen on the 16th of May. And then finally, that the defendant moves for an order excluding all statements made by the defendant after his arrest on the grounds he did not give a knowing and intelligent waiver.
And that's true, but this judge, she denied them all because Gale Rieder didn't stand up and fight for me like a real lawyer. She didn't.
Remains before the court. No, Your Honor. Ms. Rieder, do you wish to put on evidence?
We do not, Your Honor.
Why not? And I had a whole folder. I had a whole folder.
Thank you.
I believe that the motion to dismiss for lack of proper...
I had a whole folder of evidence at my court date. It was right here. Whole folder. Medical reports. Oregon State Bar.
Thank you, Your Honor. Starting with the search of the cell phone, Your Honor, clearly the officers were there lawfully based on their investigation. They had entered the room, found the defendant's wife, who was clearly prosecuting herself. The defendant was then, he came out, I guess as you said, his hands came out first and said, "Hey, I'm here." Brought him out at gunpoint, took him in custody for officer safety concerns.
Voters, man, they lying. I got evidence.
We just heard from Officer Hernandez about that contact, about the search. He verbally read him his Miranda rights. The defendant acknowledged those rights. He did not sign the card because he was handcuffed. The detective informed the court that based on officer safety concerns at that particular juncture, it's very normal for them to keep them handcuffed, and they will write handcuffed on the line of the signature of the defendant, and then the officer signed that. After the Miranda rights were given, then the defendant made several statements, including the consent to his search of his cell phone. In regards to that particular card, as you can see, it says room and car, and I had the officer clarify that was the first verbal consent that the defendant gave to the search of the entire room and its contents and the car. Here then, when the defendant was allowed to be unhandcuffed because the officer's safety concerns were alleged, then the defendant signed that card saying, "I still consent to all of this." And I asked the detective specifically, was that...
They lying. I never ever said
yes.
This. I'm telling you with all my heart and in my mind, I got all this evidence showing. And why didn't Gale, as my public defender, put on my evidence?
The only way to get into the phone, which was the 0550 code, and then the defendant willfully gave that over to the detective to finish searching the cell phone. All the contents that are on the cell phone, of course, at that point, would be admissible evidence showing the relevance to the different text messages in regards to Queen Moneymaker, which is his wife, we learned through Detective Smith.
This case is going to make somebody's career go
she was getting ready
over.
to do a lick. And then, of course, the drug
Because of the
records.
slanderous remarks they
So,
made.
I asked the
Convinced
court
this
to deny the
judge
motion
to
suppress
throw
in
out
regards to
all
the
my
search of the cell
evidence.
phone. Moving to the defendant's statement, since we're already talking about the Miranda rights that were read to the defendant,
That
I
were
asked the court
broken.
to say that was a willful involuntary
No, it was not.
waiver on his part.
No, it was not.
And that he did agree to talk to the officer.
No, I did not.
You heard from Detective Hernandez.
You heard
many
lies.
different quotes, and he specifically
Many
quoted
different
those
lies.
in his report.
His report is off. Roger Smith, the only one that wrote a report.
Contact that he was having.
Hernandez don't have a report.
And then saying, "All right, I'm going to be straight with you.
That's a lie.
I portray myself to be a pimp, but it's just something that I've done because of how I grew up and how I lived my life."
That's a lie. I've been in foster homes and in prison.
Expect from me. Again, that's an indicator that goes towards the promoting prostitution. His statements about what his role is, the fact that he's hiding in there. The reason I elicited his wife's statements was effect on listeners. She's not here for this motion. Didn't need her to be. It really was the.
Why didn't you need her? You didn't need her in the indictment process. You didn't need her in the motions hearing. Why didn't you need the supposed victim, Douglas Christopher Hanson?
Yes,
Why?
Together, I'm there for her protection, etc.
This is all lies and slander.
His own statements again, Your Honor. There was nothing in
I never talked to these cops.
Understand the questions, that it was not voluntary. I asked the detective, was he complaining of pain or discomfort or not understanding?
No, he didn't. No, he didn't. No, he did not.
At some point, he said, I'm going to be sick, and he threw up. But again, even after that, there was no talk about, I really don't understand what you're doing, what's going on here, I'm not voluntarily consenting to any of this. Nothing of that nature occurred, Your Honor. In fact, the detective said that sometimes the defendant was actually laughing at some of his questions. So I think that also shows the voluntariness and the defendant's knowing waiver here. Your Honor, I was not privy to the doctor's testimony.
Look at him, stumbling over his words in fear.
That portion of the case.
How you know?
My understanding from what the doctor.
Each mind is different. He could have asked my doctor something totally different than what the other man offered.
Cause him some sort of maybe pain or something like that, but nothing about voluntariness of statements or not knowing.
Why everything is good on their angle, but nothing is good on mine.
He just said,
I told him,
whatever I have here, that I get sick.
I never said it's common.
I don't think there was any correlation from what I heard to understand the doctor's testimony.
Oh, this man is so
not voluntarily waiving his rights here. So I'd ask the court to deny that motion to suppress his statements. Lastly, on venue, Your Honor, I think the court's
it's a law. I don't care what your argument is.
That talked about
fruit of the poisonous tree says none of this is legal.
You can't argue venue in the middle of
you can't argue none of this.
Not something the state needs to actually prove venue, but they can raise it pre-trial, and that's what's been done here. As Ms. Rieder indicated, the only issue of venue is to count 2. So let's look at the count 2, Your Honor, which is the delivery of oxycodone. Or Oxycontin. This is an actual constructive delivery.
So why am I charged with a delivery of a controlled substance within 1,000 feet of a school?
Sell the drugs. That's delivery of a controlled substance by constructive delivery.
But I don't have that.
He had $1,200 in cash.
That was my money.
Which not only goes to helping prove the prostitution, but it also goes to showing the sale of drugs. He also has the oxy on him. It's not actually on him, excuse me. It was found in his wife's purse, is what I believe the testimony was. But again, it's his prescription. So yes, he lawfully has that, but he's not entitled to then try to sell that. That's what he was
I never tried to sell it.
Dating back, I think, from March up until the last one, which is the evening of May 15th.
I wish God to send somebody to help me.
And that he's saying,
you know,
I'll sell you
that's
these.
all I want.
Pills. Well, weird. It happens to be 50 actual pills that are still left in the bottle. They're 5 milligram tablets, exactly the same. And on or about, Your Honor, it doesn't have to be a specific date. The court knows that that's not a material element that we have to prove. So in any situation, again, where a defendant may have sent that physical text message at some other location or at a day or two before or a day or two after is irrelevant. The fact is that he's constructively delivering it when he's in possession of the phone. There's indicia of delivery on the cell phone, and he has the drugs with him at the time, and he has cash with him at the time.
So I'm not allowed to have money on me. It's against the law for me to have money. Because I'm a black man.
Really, we have venue when any material element can be proved, and any element it may exist within this county. Well, he's possessing these drugs. He has the.
I can possess my own prescribed medication. What do they not understand about that?
And with the drugs.
I never went to Salem with the attempt to sell any drugs. I went to Salem with the attempt to stop my wife from committing a crime that they eventually charged her for and me.
The only evidence that we have of the attempt to sell the drugs is the May 15th. That would be.
That's what they evidence. That's their evidence that my lawyer's reading off to them.
Johnson
making it seem like it's mine. I got way more evidence than they think.
I would suggest
Way
to the court
more.
that there is insufficient evidence for
Right.
you to lie in Marion County on that case.
And she still denied it. Helping.
Okay. So, it's not always a circumstance that the court hypothetically agrees with, but isn't it the case that if I have a prescription for X and it's filled, and I then give my prescription, my bottle of X to Sam, haven't I delivered a controlled substance? And so in this situation, because it's in his wife's purse, not his possession, her possession, isn't that evidence of delivery within 1,000 feet?
No, it's not. Hell no, Trip. Why
I think
would
you
you
have to know
think
more
that
about
way?
the
As
circumstances of that, because
Right.
that means that every time in Fred Meyer, if I may, that I get a prescription filled and I've got 2 cantaloupes in my arms and I say, here, honey, hold this, and I hand him the prescription, I've delivered a controlled substance to my husband. So I think that's a little bit overbroad.
Okay, fair enough.
Application.
Fair enough.
Okay. In this case, the money that Mr. Johnson has is not evidence of drug delivery.
It's not.
If there wasn't a
Because I showed her
attempted
evidence, but she
delivery, which is
excluded
what
it out.
The text
Listen
messages
to her.
are more indicia of. Then we have no idea where that attempted delivery took place.
Don't,
In fact,
because
it's
I was
not a
never in
constructive delivery
Salem.
situation here in Marion County. We've got an attempted delivery, perhaps. But
So
it's
again, why do I get
because
delivery
the
of a controlled
oxycodone are
substance
still
if it was an
in Mr.
attempted delivery?
Johnson's constructive possession, with them being in his wife's purse? That's what we would argue, and we have no idea where that text was sent.
Right.
With regard to the other
Neither
two
did the
motions,
district attorney.
The motion to suppress regarding his statements and the motion to suppress with regard to the search of the cell phone, those are inextricably tied to his physical condition.
Which
because
I
he
took a
cannot
psych
consent to his
evaluation,
statements voluntarily,
and it shows
and he cannot consent to a search of the
proof.
cell phone
It showed proof how
as well.
ill I
And as
was.
this court heard from Dr. Harbison, the metformin that Mr. Johnson was given did cause him nausea and perhaps some disorientation. Dr. Harbison testified that there were adverse effects to that prescription being given to Mr. Johnson when in fact he was not diabetic.